A South African legal expert, Hilton Hart, says the judgment of Judge Retson Kapindu in the judicial review of the Bushiri extradition case was flawed. He argued that there was no prejudice at all if witnesses were to use video conferencing to testify in the case, adding that due to the spread of the coronavirus, it was only prudent to allow the use of video conferencing to prevent people from traveling to Malawi.
I don't think it was such a difficult application to have taken so long to actually give judgment, because it was not even that extensive an application. It was just mere formalities to say that how is the witnesses going to testify, and I think put in place the necessary precautions. They can testify via video link, because I don't see any prejudice in them testifying in person in front of the Bushiris, because I know the South African law makes a provision in the Criminal Procedure Act that witnesses must testify in the presence of the person that is being accused, so that they can face the accuser. But I don't think there's a similar provision in the Malawian Penal Code. So for me, but also with the corona pandemic currently on our hands, I think the video link is the most viable, reasonable course, with travel restrictions and also all these things people need to go through, testing and getting witnesses. There's just a costly and an expensive and complicated exercise that a reasonable judge should think via video link. If we put all the safeguards in place so that their rights are guaranteed, then it shouldn't be a difficult thing to do.
Meanwhile, in Malawi, the state of Malawi, represented by Dr. Steve Kayuni, the Director of Public Prosecution, says Malawi will comply with the ruling of the High Court.
I can say that the High Court has rendered its decision on the review that was made at the instance of the state. The main issue that was in it was to do with our obligations as a country to another country in terms of extradition issues, and further to that, on whether specifically the witnesses would physically avail themselves for court proceedings. So the Honorable Court has given directions to the lower court as to what is really supposed to happen. There are issues that have come up. The main issue is to do with the physical presence of the witnesses, and whether, in accordance with the law here, a preliminary inquiry is a way that a court can proceed. So the court has stated that our laws here point to the fact that a possibility of the witnesses being taken into deposition in South Africa, and the same is relayed in an acceptable way that it's sent here for the processes here to be undertaken.
The High Court, presided over by Judge Retson Kapindu on Tuesday, dismissed the application by the state of Malawi, which sought to review a ruling on whether South African witnesses should come to Malawi and testify in the ongoing extradition case or through video conferencing. This was after resident magistrate Patrick Chirwa had delivered a judgment in March 2021 asking the witnesses to appear physically to testify in the Malawian court. Judge Kapindu, in his ruling on Tuesday, said, "Whilst the law generally requires physical presence in court by the witnesses, this is not an inflexible thumb rule, as the court has the discretion to allow remote or virtual online court proceedings where witnesses may testify virtually, where the court finds this necessary and practical." He further said the remote or virtual hearing carried a number of and did not have all the advantages of a witness being face-to-face, saying that a court may only allow virtual hearing where there is satisfactory grounds for doing so, and the decision lies in the hands of the court. Meanwhile, defense lawyer Wapona Kita said Judge Kapindu has not given an order to the magistrate Patrick Chirwa on how to conduct the extradition, but has given many options to the case.
We are happy with the outcome, with the judgment which has come from the High Court. We are happy because substantially it has gone in the favor of our clients, because we have argued all along through the magistrate court what a preliminary inquiry means, and that is the issue which the DPP was not satisfied with. Now, come to the High Court. The High Court has made it clear that the magistrate was right in the way he chose to approach the extradition proceedings by way of a preliminary inquiry. What the DPP was asking for in the High Court is that the magistrate court should just adopt the statements, which is not what a preliminary inquiry entails. It requires the physical presence of witnesses. So the judge has in fact dismissed the grounds of review which were put forward by the DPP and has agreed with the magistrate. By agreeing with the magistrate, it means he's agreeing with us, because those are the arguments which we are raising before the magistrate court, because it's the DPP which took the matter to the High Court. What the ruling says is, yes, ideally, that is the default position. That's what a preliminary inquiry entails. We should expect the witnesses to come to Malawi physically. However, the judge has gone further to say that in exceptional circumstances, the magistrate should be open to circumstances, and if so it requires, he can allow the witnesses to give evidence through video conferencing. In other words, maybe I should clarify that point very clearly. The judge has not made any order to the magistrate on how to proceed. He has only opened up the options. So what it means is that the magistrate will have to wait. Should there be an application from the DPP on how they want to proceed, then the magistrate must listen to that application and see if there are those exceptional circumstances. Otherwise, as things stand now, the ruling of the magistrate remains that he wants those witnesses physically.
It will be interesting to see how South African government emplains its witnesses to Malawi after recent media reports suggested that the witnesses might not go to Malawi for safety reasons.
What I've also tried to do is track some of the witnesses, which of course we had been in communication with since about 2020. You'd remember that we first brought you the story where we broke it, where witnesses had alleged that there had been, of course, by the self-proclaimed prophet Bushiri before he had fled the country. And what it is right now is that they had actually told me that they would not be heading to Malawi because they cite that they fear their safety might be in jeopardy if that's the case. And now they're pinning their hopes on the fact that the application which has been brought by the chief magistrate in Malawi through the High Courts can be successful.